Hi, I'm Arizona lawyer Julie LaBenz, and today I want to talk about how to use and how not to use AI when you're representing yourself in family court. Now, first of all, understand that yes, AI can be a helpful tool, but it can also completely destroy your credibility with the opposing side as well as with the court if you're using it incorrectly. And one of the biggest problems is that AI is not always accurate when it comes to legal citations, both cases and statutes. And if you're going to use AI and you're going to allow it to cite to cases and statutes, and then you just file that with the court, you're running a huge risk because you could be sanctioned for that. The court could order you to pay attorney's fees for the opposing side. The court could enter separate sanctions against you. Right now, the courts are taking some pretty strong positions against people who use AI incorrectly in the pleadings that they file with the court. So, because you're not trained as a lawyer and because you may have no background experience with the law, it's really critical that you don't just take whatever AI gives you and run with it. Because unfortunately, AI is wrong many times. Just last week, I was utilizing AI and it gave me the incorrect statute 5 different times. I had to correct it and give it the proper statute. It has given me cases that don't even exist. It cited cases that exist, but say that the cases stand for something that they do not stand for. And those are the things that really bother the court. So, if you're going to use AI, you need to be very selective in the way that you're using it. And you must double check, proofread, revise, and really do some additional work with whatever AI produces. Okay, with that said, one thing that I would specifically like to talk about today is how you can utilize AI if you're in the following situation. Let's say that your ex has an attorney and that attorney has filed a motion for temporary order. This means that you're in a position where you need to file a response, and the court doesn't have a great set form for the response to a motion for temporary order. So, when you're in that situation, I'm going to give you a step by step playbook that you can use to utilize AI. But again, keep in mind that whatever draft AI produces for you, you need to review it, you need to revise it, you need to make it into your own, and you need to make sure it's correct. All right. So, before we go any further, if you're enjoying this content, if you find this to be useful, I would so appreciate it if you would give me a like, if you would subscribe, and of course, if you'll leave a comment, because the comments that you leave, I will potentially turn into a video in the future answering any questions that you have. So keep in mind that this is legal information only. I'm not giving you any legal advice. I don't become your attorney by answering a question or by you watching this video. And my information that I share is really based in Arizona because this is where I'm licensed to practice law. However, I try to give information that can apply in any jurisdiction. However, realize that I am coming from an Arizona-based perspective. Okay, with that said, let's go back to this potential situation where you are needing to respond to a motion for temporary order that's been filed by opposing counsel in your case. Now, just to give you the proper framework, what a temporary order in family law is this interim order that the court can issue upon the request of one or both of the parties. And it's to address issues that need to be addressed while the case is pending, because the court acknowledges that it can take a significant amount of time between the time the case is initiated and by the time it's resolved, and that the parties need certainty on certain issues during the pendency of the case. And the way the court addresses that is through what's called a temporary order. A temporary order can address issues such as parenting time, decision-making for children, child support, spousal maintenance, the in-term division of certain community property, payment of attorney's fees. There are certain set issues that a temporary order can address, and this can come up in the context of a divorce or in the context of a custody case. So you've received in the mail, via email, maybe by both means, opposing counsel's motion for temporary order. Now, this is my suggested procedure for you to follow. Number one, you want to take that document and you want to copy and paste the language into a Word document. So if you have received an email with the motion for temporary order attached, you want to open up that PDF and then you want to copy the text and paste it into a Word document. You want to read through the motion, obviously, and you're going to want to edit or remove any personally identifying information. So first names of the parties, first, last names, names of any children, dates of birth, addresses, account numbers, anything that has any personally identifying information. You're going to want to edit that either by removing it or making it into something that doesn't give your personal information. So in other words, changing the name of one of the parties to husband or wife or mother or father and doing that consistently throughout the document, changing the name of a child to child 1 and child 2, for example, just taking out dates of birth. You can change an address to 123 Street. Just making things so that you're not putting any personally identifying information into the AI that you're going to use. Once you've done that, then, and I'd read through it a couple of times to make sure that you've completely taken out any personally identifying information from the document. And while you're doing that, another thing that you can do is be jotting down some notes of things that you disagree with and what your requested outcome is on each request in the opposing party's motion. So for example, if the temporary or the motion for temporary order is requesting a particular parenting plan, you can jot down some notes. Are you in agreement? Are you wanting a different schedule? Make some notes about where you're in agreement and where you're in dispute. And on those issues that are in dispute, what is your requested outcome on those issues? Okay, next, let's say you're going to be using ChatGPT, for example. So you'd open that up. And then I like to start with the following prompt, which is, you are an Arizona family law attorney with 30 years of experience. So I start the prompt with that framework. I tell the AI that this is the perspective that they're writing from. I would then say that you represent, let's say, husband or father in a divorce or a custody case, whatever you're dealing with, and the opposing counsel has filed a motion for temporary order. And then I'll say, I'm going to provide you with a copy of the motion for temporary order, and I want you to draft the proposed response. Here is the motion. And now this is where I would copy the edited version of the motion into ChatGPT, and then I would have ChatGPT draft a response. One other thing that I would add before I have ChatGPT produce their response is I would say, you don't need to create a case caption. You don't need to needlessly bold various words, because I find that ChatGPT just wants to bold words all over the place, and a professional does not write that way. And also no lines between paragraphs. When I submit a pleading to the court, I'm not putting lines between my paragraphs, which AI tends to like to do. Okay, so then the response is going to come out. I copy and I paste that into my pleading paperwork. I'm assuming that with the pleadings that you've already filed with the court, that you've got some caption, some pleading template that you're using that has your case caption on it. If you haven't done so already, you should create that. Okay, so you're going to put that into your Word document or your Google Doc, whatever you're using, and you want to start reading through it. All right. Highlight any citations to statutes, highlight any citations to cases, highlight any citations to rules of procedure, because you're going to need to double check all of those, meaning anything that you highlight that is in your proposed response, you need to go do searches and you need to make sure that those statutes, those rules, or those cases are actually real and that they stand for what you're claiming that, or what AI claims it stands for in the proposed response. So at this initial stage, you just want to highlight those so that you have a reminder, okay, I need to double check all of these. Next, you're wanting to read through it and really focus on the substance. Number one, is this addressing each paragraph that's in the motion? And number two, is this conveying your requested outcome and your defenses or arguments against what has been raised in the initial motion? And you're going to want to incorporate those positions and those arguments if they aren't already in there. So, for example, let's say that there is an allegation in the motion that you aren't available for parenting time on Tuesday nights. However, you've currently had a change to your schedule and you're now available on Tuesday nights, and that's not in the draft of the response that AI drafted. You're going to want to explain that as well as detailing out what your proposed parenting plan is. Okay, so you've done your initial review, you've incorporated your counterpoints, you've incorporated your requested outcomes, you are taking the time to double check every single citation that's in the motion or in the response. From there, I would do another comparison. I would read through the motion again while I'm looking at the response and making sure that, number one, the order is tracking, because if, for example, the first argument in the motion has to do with mother's parenting time request, then the first paragraph in the response should be dealing with father's, response to mother's parenting time request. In general, motions for temporary order follow the following sequence. There's first a set of factual allegations that can be numbered paragraphs. Then there's a section that cites any relevant law. Then there's a section that makes arguments that incorporate the facts and the law. And then there's a conclusion with a list of what is requested and in terms of what they want the court to order in the temporary order. So the response should respond to each of those sections. So, for example, if the first part is a set of factual allegations with numbered paragraphs, then the first part of the response should be a response to those facts where you're admitting or denying what has been alleged in those numbered paragraphs, and where you can also allege your own facts, either directly in response to a numbered paragraph or by adding additional numbered paragraphs with additional factual allegations. And then when you get to the law and argument section, your response should be in response to each part of that law and argument section. So if, for example, the first argument is about what mother's requesting for legal decision-making, you would be responding about whether you're in agreement or why you disagree and what you're asking the court to do and why your request is in the best interest of your children. If the next section is about mother's parenting time request, then your next section would be about what you agree with as far as mom's parenting time request, what you disagree with, and why your requests are in the best interest of the minor children. And of course, if there's any factual disputes and things that you want to explain within that section, you can certainly do that. If the next argument made by mother is what child support should be, again, your third section would be about whether you're in agreement with mom's child support request. If you're not, what you're asking the court to do and why your request is proper. And this would be a great time to add as an exhibit to your response your proposed child support calculation. So as you can see, there should be this mirroring where you're taking each part of the motion and you're telling the court where you stand on each thing that is being raised in the motion. Now, if there's something that is not raised in mother's motion that you also want the court to address, for example, let's say that mother's motion addresses only child support and parenting time, but you're also wanting the court to address legal decision making, then you're going to want to weave that in to your motion so that all issues that need to be decided in terms of the temporary order can be decided. Now, once you have a draft of your response, and again, you're going to want to make sure that in terms of this next step that I'm going to give you, you're going to want to make sure that the response doesn't have any confidential or personally identifying information in it. But the next thing that you can do is you can go back to ChatGPT and you can, again, use that initial prompt. You're a family law attorney in Arizona or whatever your state is with 30 years of experience. You represent mother, you represent father. Mother filed a motion for temporary order. I'm going to provide you with a copy of her motion. I'm also going to provide you with a draft of the motion for father's response to the motion for temporary order. And then you can say, identify the weaknesses in father's response to the motion to temporary order. Then you can start looking, once ChatGPT gives you the answer, you can look at those positions and you can see if there's any additional revisions or additions that you want to make to the current draft of the response based on what are potential weaknesses. Okay, so I know I just gave you a lot of information, but hopefully you've been following along. Hopefully I've broken it down so that it's easy to understand. Of course, if you have any questions, throw those down in the chat in the comments so that I can potentially do a future video answering those questions. But I think that the biggest takeaway from this video is that you don't want to rely on AI as if it's all knowing and as if it's a legal expert. It's a tool to help you, but it isn't the end of your tasks. It isn't just accept whatever it produces. Instead, it can be a helpful tool, but you've got to make sure that it's accurate. And like I mentioned earlier, there's some risks if you don't do that. You could be sanctioned, you could be ordered to pay attorney's fees for the other side. And then one other potential sanction that I didn't mention earlier is that you could be deemed a vexatious litigant. And if that happens, then your ability to file pleadings with the court becomes curtailed. You have to get the court's permission. There's just some really serious consequences if you're just going to blindly rely on AI. And you really don't do yourself any sort of justice or good service by blindly relying on AI. In other words, it's not building your best case for you. You need to participate and really put your personal touch and make sure everything is accurate and correct. Okay. I'm Arizona Lawyer Julie LaBenz. Thank you so much for watching this video. I hope that you found this information useful. If you did, I'd appreciate it if you would like this video, share it, become a subscriber. so that you don't miss out on any of my content. And of course, if you have any questions or comments, please put those down below. All right, thanks so much. And I'm wishing you all the best with your case.